This is Caroline Kobzanski, and you're listening to UC3P.
Welcome to the University of Chicago Public Policy Podcasts. This is UC3P, our eponymously named podcast on policy, politics, and current affairs. My name is David Raban, and I'm the production manager for what we like to call the main page. Today, we talk with Barbara McQuade, law professor at the University of Michigan and former U.S. Attorney for the Eastern District of Michigan. We asked her about cybersecurity, police profiling, and how encryption has changed law enforcement. We'll get to the interview in a moment, but before we do, I want to ask you a question. Have you subscribed to UC3P? If not, it's really easy. Just go to uc3p.org and you can subscribe to all of our podcasts using your favorite podcast app. Again, that's uc3p.org. And if you have subscribed to UC3P, recommend us. Whether that means leaving a 5-star rating on iTunes, writing us a good review, or talking about us with a friend, all the podcasters at UC3P really appreciate your support. Now, without further ado, here's University of Michigan Law School professor Barbara McQuade.
Okay, you are listening to UC3P, University of Chicago's Public Policy Podcast. We are with Barb McQuade, who is former U.S. Attorney for the Eastern District of Michigan, currently professor from practice at the University of Michigan Law School. Under her leadership, the U.S. Attorney's Office prosecuted a number of high-profile cases, including the so-called underwear bomber, former Mayor Kwame Kilpatrick for public corruption, and a case that every law student, but not necessarily every listener, will know, Carpenter versus U.S. Professor McQuade, Barb, we're thrilled to have you with us.
Thanks, Irene. Glad to be with you.
I was lucky to have Professor McQuade as my first-year criminal law professor, and it really introduced me to the breadth of government lawyering. So it will link up nicely with the policy concerns of this podcast. Let's start with technology. You worked a lot with technology issues during your tenure, and over the last few years, it has become clear that the courts are treating data and technology in general as something different than traditional physical evidence. Why is this happening, and what does it mean for smartphone users, GPS users, who are basically everybody?
I think you're absolutely right. We are seeing the court wrestle with technology. You know, in the past, we have seen courts try to analogize technology into things that are familiar to us, referring to file folders as file drawers and things like that. But I think that technology has gotten to a place where there is not always an easy analogy to the real world, the physical world. And it's causing them to reconsider some doctrine that has been long-standing. You know, the framers of the Constitution were brilliant. They used words like reasonable that could be flexible and change as the world changed over time. But we have such a profound change with technology that some of the doctrine that has developed over more than 200 years doesn't quite fit so well. For example, there's the border search doctrine, which says that you don't need a search warrant at the border to look through people's stuff. And the idea there is that if someone is bringing in a suitcase that might contain a weapon or contraband or something dangerous, then agents at the border should be able to look at that and protect the sovereign of the United States from anything that might be coming in. How does that translate when it's someone's cell phone? Certainly if there's contraband on the phone, pornography or something else, maybe there's an interest in stopping that. But now a cell phone contains, a gateway to your whole world. It has access to your files and other things. And so the common analogy that's been used for decades just doesn't quite fit anymore. And we're seeing that in lots of different areas.
This mode of technology is really pushing a lot of the core concepts and vocabulary of this body of law. I mean, you mentioned that there's an issue of whether technology can be considered a container. There's also an issue of boundary pushing with whether things like access codes are testimonial. So do you think that that language is being strained to the breaking point, or can it accommodate these changes?
It really is, and I think at some point we might have to rethink several of these doctrines. One is the third-party doctrine that talks about when documents are held by a third party, like a bank or the phone company. They don't belong to you. You don't have standing, and you can't prevent it from being turned over to another person because you've already given it away. But when we talk about location data, which is incredibly intrusive, is that qualitatively something else? Or like the example you just gave, Irene, when we talk about codes, passcodes and things. Ordinarily, the Fifth Amendment right against self-incrimination protected us from giving anything that was testimonial and self-incriminating. And so you didn't have to say anything that was the product of your own mind. And so in a strange way, the law comes down differently, whether it's asking you to produce a key to a lockbox or a thumbprint versus a password that you've composed in your head, because the password is testimonial, whereas the key and the thumbprint or the facial recognition are not. And, they're used in identical ways. And so the idea that they would have a different outcome just because of the ways that they're stored doesn't seem to make sense logically, although it is the logical extension of the doctrine. So at some point, we may see a need to just make a wholesale change in the doctrine itself.
And at the same time that the courts are struggling with these issues, law enforcement out in the field are struggling as well. The DOJ has noted that it's becoming more and more of a problem that people are going dark, not just people who are transacting on the dark web, but people who are concerned with privacy, who are using encrypted apps. What does this mean on a practical level for law enforcement, for prosecution, and what's being done about it?
It's a problem that the FBI is quite vocal about, referred to going dark, and it happens most often when people are using encrypted apps. I saw this when we would do undercover work to try to detect people who were talking about engaging in violent extremism. You might see them talking to each other, and then they would say, let's go to WhatsApp or some other encrypted application. And then law enforcement was no longer able to watch their conversations. Even with a court-ordered warrant, law enforcement is unable to get that information. And so I know that the FBI director, Chris Wray, talks about how for the first time in the history of the United States, there are places that law enforcement cannot go even though it has a valid warrant. So it's the technology that is preventing law enforcement from going there. The counter argument to that is that in some ways law enforcement was enjoying a windfall, that at the origins of the Constitution, there was nobody who was communicating by phone, let alone text message. And it had become a treasure trove of communications for law enforcement. And the idea that there are some that are now out of bounds is really no different from people having face-to-face conversations 200 years ago. But it is certainly a growing frustration for law enforcement. They may be involved in a case of kidnapping, of child exploitation, and much of the content is stored on an encrypted phone or other device, and they're unable to get to it.
To zoom out a bit, based on what you're saying, it seems like what's behind this issue of access are at least two different paradigms of the relationship of law enforcement to civilians or to the people. The one is a tug of war where you might have a dynamic where at some point there's a windfall and another point people are having less privacy. And on the other hand, there's a social contract according to which, law-abiding citizens should be willing to trade certain protections or privacies for the benefit of the rule of law. It's not clear how to navigate those two paradigms. Do you think that one or the other explains the dynamic more? I mean, you talked about it as a windfall, but it might be the case that what's going on out in the field can inform the evolution of the doctrine.
Yeah, and I think it might. Already, you often see this where people in law enforcement try to demonstrate that they can police themselves, lest they end up with a more drastic rule coming from the courts. So, for example, in the border search doctrine area, we've seen Customs and Border Protection already impose on themselves some rules. that they will only do what's called a basic search on a device when someone is at the border without reasonable suspicion. And then if they have reasonable suspicion that they can articulate, only then can they take a broader look to see what is on the device. And so I do think that there is an awareness that change might be afoot. And so I think that courts will look to practitioners just as practitioners look at courts, and will continue to evolve. It's just that some of the doctrines that seem settled now seem to require a little bit of reflection and rethinking because the technology has rendered the prior doctrine somewhat obsolete.
How is it possible that at the same time that you see people and entities withdrawing from surveillance, that theft of intellectual property is emerging as a or maybe the major form of espionage?
Well, part of it is the ease with which people can steal it. We had some cases when I was working in the U.S. Attorney's Office where we had employees, insiders, who stole data from major automakers, and they were able to store on a thumb drive huge amounts of data about research and development that had taken many years to put together through major investments of the auto companies. And there was a time when you had to steal the copy or go photocopy the secret records. You had to be able to find them, locate them, take them out of their proper place, make a copy, or take them and then somehow secrete them out the door without being caught. That was quite an undertaking. Now, from your own desk, an employee could go on, find the documents, copy them, download them to an external thumb drive, or even transmit them electronically without ever taking anything out of the building and transfer them to someone. And so I think the ease of transferring data has created some vulnerabilities, and business is learning to protect against that. Cybersecurity is a growing area. There was a time, I think, when people were naive about how that information could be taken. I know most businesses now have segregated documents, need to know, so that one engineer doesn't get to know about every engineering project in the entire company, only the ones that he's actually responsible for. So in that way, they can limit the damage, detecting breaches, detecting hacks. But there's always going to be new technology, and so we will always be playing defense and probably always one step behind and catching up.
But as necessary as these silos and firewalls are to protect the theft of information, don't they necessarily change the way that people work, both in government and private industry? It seems like that would inhibit collaboration and make it harder to spot trends across data sets.
Yes, I don't know all the ways that it impacts work. I can just tell you, even in my own work, when I was at the U.S. Attorney's Office, some of the work that I did was secret or even top secret, which meant I couldn't work on it on my desktop. I had to go into a special room called a SCIF, Secure Compartmented Information Facility. I had to work off of a special computer. I had to lock up the hard drive at night in a safe. And all of those obstacles definitely prevented me from talking about the case with colleagues as freely as I might have wanted to, because we had to be in that room to talk about it, and there was only a limited set of people I was allowed to talk to about it. I couldn't take any of that work home. There were certain times of day when it was not convenient to go do that work. And so I know it affected my ability to work, and I think about how many other people are dealing with confidential information or sensitive information. They too are dealing with those kinds of things. So it certainly prevents open collaboration. It also prevents joint ventures and the kind of idea sharing that you might otherwise engage in. You can't go to a conference and brainstorm about these kinds of things if you're dealing with secrets and concerned about people stealing them. But I think that is part of the reality, and systems need to evolve, but we need to recognize that these changes are taking place.
Hey UC3P listeners, I'm Thomas.
And I'm Nick.
In the United States, public faith in the military remains sky high, while trust in other government institutions sinks to an all-time low.
At the same time, fewer than 1% of Americans will ever serve in the armed forces, and the cultural divide between active duty troops and the civilian population continues to widen.
UC3P presents a new series, Thank You for Your Service, where we take a deep dive into the complex world of civil military affairs.
We'll address the politicization of the military, defense policy in the news, and the importance of staying informed in a democracy.
Join us on Apple Podcasts, Spotify, or wherever you get your podcasts as we explore how our professional military institution relates to the society it serves.
There are also a number of efforts now in many cities to be more proactive in law enforcement, crime reduction,